Hello, my name's Cundy. This video will look at the recent High Court case of Lee and the Assistant Coroner for the City of Sunderland and others in the context of the court's approach to the application of Article 2 in healthcare cases. Inquest practitioners who act for families or NHS trusts will be familiar with the need to consider the scope of an inquest where healthcare agencies have been involved with the deceased, whether they're arguing to limit that scope or extend it. All parties, and decisively the coroner, need to consider whether Article 2 is engaged in these cases, and whether as a result the question of how the deceased came by her death has to be widened to consider in what circumstances that death occurred in order to meet the requirements of Section 5.2 of the Coroners and Justice Act 2009. Now, the case law in this area has developed apace since Middleton set out the requirements for an Article 2 compliant inquest in 2004. And the case of Lee is a further indication of the boundaries being pushed in respect of Article 2 engagement in psychiatric cases. It might be helpful at this point to outline what the Article 2 duties are before then considering how the courts have applied those issues to inquests involving healthcare. Article 2, of course, enshrines the right to life and prohibits the taking of life by the state, except in certain limited situations. And it imposes three distinct duties on the state. The first is a negative duty to refrain from taking life, save in exceptional circumstances. The second is a positive duty to conduct a proper and open investigation into deaths for which the state might be responsible. And the third is a positive duty to protect life in certain circumstances. Now, that third positive duty has two elements to it. Firstly, there is what's called the general or systemic duty on the state to put in place a system of laws and administration to protect against threats to life. And secondly, there's what's referred to as the operational duty on the state to take appropriate steps to protect an individual whose life is at risk. Now, the European case of Osman and the UK from 2000, which set out the operational duty, was dealing specifically with the obligations on the state to take steps to protect individuals from the criminal acts of others. And Osman concluded that the state would breach the operational duty if it knew, or it ought to have known, of the existence of a real and immediate risk to the life of an individual from the criminal acts of another, and then failed to take steps which were within its power and which might reasonably be expected to avoid that risk. But since Osman was decided, the operational duty has been held to apply to a much wider range of situations than the threat to an individual from criminal acts. The House of Lords case of Middleton in 2004 set out the requirements for an inquest that is compliant with the Article 2 duty to conduct a proper and open investigation into a death for which the state may be responsible. And it's important to remember that it's not the purpose of an inquest to determine whether there has actually been a breach of either the operational or the systemic duty in the case of the deceased. The purpose of an inquest is to answer the four statutory questions, namely who the deceased was and how, when and where she died. For Article 2 to be engaged in an inquest and for the hearing to consider in what circumstances the deceased died, as required by Section 5.2, there has to be an arguable, as opposed to an actual, proven or provable breach of one of the Article 2 duties. So what appears on the face of the Osman case to be the limited circumstances in which the state will owe an operational duty to an individual were pushed wider by Middleton and wider still in subsequent cases, both European and domestic ones, which considered the limits of the state's responsibility for individuals in the context of the provision of healthcare to them. Now, as matters currently stand, there's a divergence in the way the courts have dealt with the engagement of Article 2 in, on the one hand, those healthcare cases involving medical negligence, and on the other, those involving the treatment and care of psychiatric patients. The 2018 judicial review case of Parkinson and the coroner for Kent followed the European cases of Powell and the UK from 2009 and Fernandes and Portugal from 2017 in seeking to limit the application of Article 2 to cases of alleged medical negligence. And these cases make clear that the state is obliged to adopt appropriate measures to protect the lives of patients in hospitals, namely by recruiting competent staff, maintaining high professional standards, and implementing suitable working systems. But if those steps have been taken, then the courts have said that errors of judgment by healthcare professionals, or what the cases call casual or straightforward acts of negligence by the staff, will not give rise to a breach of Article 2. In inquest terms, if a breach cannot be said to arise in those circumstances, then it cannot even be arguable. But what about the position in respect of psychiatric patients rather than those who are receiving medical treatment in hospital? Now, as I said earlier, the case law has diverged from the line of authorities just mentioned in holding that Article 2 duties may be owed and arguably breached in respect of psychiatric patients. Now, plainly, if a psychiatric patient is detained under the Mental Health Act and takes her own life, Article 2 will be automatically engaged. And that's because the state has both operational and systemic duties to safeguard the life of a vulnerable citizen detained in its care. And a Section 5.2 inquest will follow in those circumstances. But what if such a patient isn't detained at the time of her death and therefore not under the direct care and control of the state? The 2012 Supreme Court case of Rabone considered that scenario in the context of a psychiatric patient who was on weekend leave from an informal hospital admission at the time of her death. Melanie Rabone suffered from depression and was informally admitted to hospital following a suicide attempt. She was assessed as being at high risk of suicide, but she was allowed 2 days home leave, during which she took her own life. Now, in his judgment in Rabone, Lord Dyson said that the starting point in healthcare cases is to consider whether it's a case that's in line with Powell and now Parkinson, where casual negligence is an operation, or one which is in line with the cases where an operational duty has been held to exist. And he went on in his judgment to refer to what he called certain indicia that point the way in making that assessment, though he was clear that they did not constitute definitive criteria in themselves. And the three indicia which he arrived at are, firstly, one, an assumption of responsibility by the state for the individual's welfare and safety, including by the exercise of control. Second consideration is the vulnerability of the victim, and control by the state may not necessarily be a factor here. For example, the operational duty has been found to be owed to a child whom the state knows to be at risk of abuse. And the third consideration was the nature of the risk. So is it an ordinary risk of the kind that individuals in the relevant category should reasonably be expected to take, or is it an exceptional risk? So applying those indicia to Melanie's case, the Supreme Court held that the trust treating her had admitted her to hospital, albeit informally, on the basis that she was a real suicide risk. Her mental health made her extremely vulnerable. The trust assumed control of her and responsibility for her. On the date on which she was granted home leave, the risk to her was real and immediate in the sense that it was significant, present and continuing. As such, the court held that the trust owed an operational duty to Melanie to take reasonable steps to protect her from that risk. Those steps effectively being by not granting her leave or detaining her if she had insisted that she wanted to go. On the question of whether the trust had breached that duty, which in this case, unlike an inquest, the court was actually determining, the court was assisted by accepted evidence that no reasonable psychiatric practitioner would have allowed Melanie to go on home leave at that point. So the Supreme Court in Rabone had no difficulty in concluding that the boundaries of the Article 2 duties could be extended to include an informal psychiatric patient such as Melanie. So bringing matters up to date then, we come to the case of Lee as the most recent consideration of whether Article 2 is engaged in an inquest that touches on the death of a psychiatric patient in the community. Melissa Lee had a diagnosis of emotionally unstable personality disorder, and she was receiving outpatient treatment in the community under a multi-agency care plan, which sought to keep her out of hospital. She'd taken a number of overdoses over time and undergone periods of both detention and informal admission to psychiatric hospitals. She took 2 overdoses requiring attendance at A&E in the week leading up to her death, but she did not meet the hospital's criteria for admission on those occasions. And she took a fatal overdose in her own home a matter of hours after her last discharge from A&E. Now, Melissa's inquest hasn't yet been heard, despite the fact that she died in 2016. Melissa's mother brought judicial review proceedings in May of 2017, challenging the coroner's decision at a pre-inquest review that Article 2 wasn't engaged in her case. And the substantive hearing of that application for JR wasn't heard in the High Court until September of 2019. The claim was brought on numerous grounds, but in essence, the family argued, as they had before the coroner at the PIR, that there was an arguable breach of both the operational duty, namely that Melissa was at real and immediate risk of suicide, and also a breach of the systemic duty, in that they considered the care plan that had been designed to protect Melissa in the community was actually inadequate. Now, the judge held that the only ground on which the coroner's decision could arguably be challenged was in relation to the existence of the operational duty. And he found that the coroner's reasons for not finding the operational duty to exist had focused solely on the issue of whether the trust had responsibility for or control of Melissa at the relevant time, so the first of those 3 indicia, rather than also assessing the questions of vulnerability and risk as required by Rabone. Interestingly, the judge didn't decide the issue definitively or quash the coroner's decision, but instead remitted the matter back to the coroner to reconsider, in light of those 3 indicia in Rabone, whether the operational duty was owed to Melissa and arguably breached by the relevant trust. So since that decision in September of 2019, the coroner in the case has received further submissions from the parties, and she's produced her own very detailed written reasons for concluding once again that Article 2 is not engaged in Melissa's case. In her reasons, she considered the 3 indicia in Rabone, and on the question of assumption of responsibility, she argued that Melissa was not detained, not in a situation comparable to detention, and not under close control or supervision. On the question of vulnerability, she argued that in Melissa's case, this was inherent rather than acute or helpless. And on the issue of risk, she argued that the risk to Melissa was long-term and chronic, and of a kind that was therefore ordinary for someone in her situation with her diagnosis. Now, while it was the coroner's view that the operational duty wasn't owed to Melissa, she did, however, go on to consider in her reasons whether, if she was wrong on that point, was there any evidence of an arguable breach of the operational duty? So she asked herself whether there was evidence of a real and immediate risk to Melissa's life which the clinicians treating her were aware of, or ought to have been aware of, and which they failed to avert, and which effectively would therefore have deprived her of a substantial chance of survival. Now, as I said earlier, in Rabone, all the parties accepted that no reasonable psychiatrist would have allowed Melanie to have home leave at the point at which she took her own life. So the evidence of an arguable breach was clear. But in Lee, the coroner is firmly of the view that no arguable breach is apparent on the evidence that she's seen. Realistically, for an arguable breach to arise in this sort of scenario, there would need to be evidence that the deceased should have been admitted to hospital, whether that was under section or informally, or conversely, not discharged from hospital, at a point where a causal link between that decision and the death can be established. Now, it remains to be seen whether the revised decision of the coroner in Lee will be met with further challenge or not. But the case is clearly a testing ground for whether Article 2 will extend beyond situations of detention, quasi-detention and informal admissions to patients with psychiatric problems who are being treated solely in the community. The coroner in Lee was determining the scope of a single hearing into an individual death, but that case may turn out to have wide-ranging implications for future inquests. I hope you found this video useful. Thank you very much for listening, and stay safe.